So the court disposed of the Anti-Injunction Act issue unanimously. Now then we get to what really, I think, in terms of the court's argument schedule, was just one issue, which is the constitutionality of the individual mandate. But in reality, it's three separate issues. Whether the individual mandate is justified under the commerce power, whether it is justified under the necessary and proper power of the Constitution, and whether or not it can be justified under the taxing power. Now, in thinking about the burdens on the challengers, I think it's worth focusing on the fact that these are three issues, and the government only needed to prevail on one of these issues. These are three separate arguments for why the federal government had the power to pass this statute. And so, if you think back to Orrin Kerr's statement that there was only a 1% chance of prevailing, I mean, part of the challenge for those attacking the statute was they really did have to run the table on these arguments. And to make matters even more difficult, I think it was conventional wisdom, and a part of conventional wisdom that did not turn out to be wrong, that there were 4 votes on the court ready to uphold the law on any one of these grounds. And so what that meant in practical terms is that in order to prevail, the challengers really needed to run the table and on these 3 issues get 15 out of 15 available votes. Now the good news is that the challengers managed the quite remarkable feat of getting 14 out of 15 votes. Bad news, of course, is that 14 out of 15 doesn't get you a majority opinion striking down the law on these grounds. But I actually think, and you may think this is hyperbole, or you may think this is somebody who is trying to spin a litigation defeat, but I think it is actually fair to say that the Supreme Court in its decision struck down the individual mandate, the mandate that each and every individual purchase insurance. The Supreme Court struck that down as unconstitutional because it said that Congress lacked the power under the commerce power or the necessary and proper power to impose a mandate to purchase insurance. Of course, it said that the statute was valid under the taxing power, but it only did that by recharacterizing the statute as not a mandate to purchase insurance, but as a tax on the status of not having insurance. And so construed, they upheld it as a valid exercise of the taxing power. But I think it's worth recognizing that that is a different statute from the statute that Congress actually passed, and it has different practical effects. I think most law-abiding citizens, if they're told that there is a constitutionally valid mandate to purchase insurance, will purchase insurance. I think most people, if told that they have to pay a tax if they don't purchase insurance, will want to know how much is the tax and how much does the insurance cost. And then they will make a rational decision about whether to purchase health insurance. And some people will purchase insurance and some people will choose to pay the tax. And the practical consequence, I believe, is that the number of individuals who will remain uninsured will be higher under a regime that simply taxes the status of being uninsured relative to an actual individual mandate that everyone must purchase insurance. Now, as I say, I'm receptive to the charge that maybe this is some spin. So don't take my word for it. Take the Chief Justice's word for it, in the sense that the taxing power law that was approved here really is different, fundamentally different from the individual mandate. So quoting from the Chief Justice's opinion, he sets up his basic argument about the taxing power as follows, quote, "The government's tax power argument asks us to view the statute differently than we did in considering its commerce power theory. In making its Commerce Clause argument, the government defended the mandate as a regulation requiring individuals to purchase health care insurance. The government does not claim that the taxing power allows Congress to issue such a command. Instead, the government asks us to read the mandate not as ordering individuals to buy insurance, but rather as imposing a tax on those who do not buy the product." And just to be more clear, he continues later in the opinion, quote, "Under the tax theory, the mandate is not a legal command to buy insurance. Instead, it is, quote, just a tax hike on certain taxpayers who do not have health insurance." Now, many of you may think to yourself, well, okay, but that's certainly, at a minimum, not the most straightforward reading of the statute that Congress passed. Well, here again, the Chief Justice agrees with you. To quote, "The most straightforward reading of the mandate is that it commands individuals to purchase insurance." But the Chief Justice pointedly did not embrace, for purposes of the taxing power, the most straightforward reading of the statute. And to the contrary, he made a point of making clear that his reading of the taxing power version of the statute was not the most natural or straightforward reading of the statute. And he made that in response to Justice Ginsburg. Because Justice Ginsburg wrote an opinion that made what I think is, at least on the surface, a fair point. She says to the Chief Justice, look, if you're going to uphold the statute on the taxing power, why have you issued an opinion that goes out of your way to say that Congress lacks the power under the commerce power and the necessary and proper power? That, as a matter of judicial minimalism, seems gratuitous. If you're going to uphold the statute on the taxing power, that ought to be the only issue that you address. And he specifically responds to Justice Ginsburg by saying, quote, "The statute reads more naturally as a command to buy insurance than as a tax. And I would uphold it as a command if the Constitution allowed it." But of course, the Chief Justice held that the Constitution did not allow that. Now, just to be one final note of clarity here, at the end of his opinion, the Chief Justice makes this distinction about as clear as I think one could. He writes, quote, "The federal government does not have the power to order people to buy health insurance." End quote. Full sentence. 2 sentences later, the federal government does have the power to impose a tax on those without health insurance. Now, so I do think, again, to emphasize this point, that the Chief Justice's own analysis makes clear that the statute that emerges is not the individual mandate. The Supreme Court, despite what you read in the papers, did not say that it was constitutional to impose a mandate on individuals to purchase a product that they wouldn't otherwise want. The Supreme Court simply and only upheld the power of the federal government to impose a tax on those who do not have health insurance. And just to underscore the notion that that really is quite different from the statute that Congress passed, I mean, remember, the point of the health care law was to get people who did not have insurance and enable them to get insurance. It was not an effort to tax those people that did not have health insurance. But that ends up being the law that gets upheld in the end by the